Did you look into her?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate.
Welcome back to the channel, where today's case dives headfirst into one of the wildest courtroom hearings you'll ever see. Imagine this. A young defendant, already out on a $250,000 bond for a violent shooting, gets rearrested for an even more brazen crime just weeks later. We're talking aggravated assault, armed robbery, stolen vehicles, and even evidence caught on Instagram. That's right, not only was he wearing a GPS ankle monitor when the robbery went down, but prosecutors also claim he flaunted stolen jewelry online for the world to see. The stakes? Massive. A mother who lost $25,000 on her son's bond. Victims left traumatized after being shot at. And a judge who's had enough, declaring this man a danger to society. Stick with me, because this case has it all: arrogance, recklessness, and a final ruling that shocks even the courtroom. And I'll break it down every step of the way.
Who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000? Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
My mom was surprised.
It's five, so she posted 50,000. Okay, there's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000.
Did you catch that? The judge points out that the defendant's own mother lost $50,000 when he violated his bond conditions, and the defendant barely flinches. No remorse, no visible concern. That's not just cold, it's revealing. In court, judges don't just look at the charges, they watch demeanor. And right here, his lack of reaction is speaking louder than words. Viewers, let me ask you, if your mother sacrificed her savings to bail you out, would you risk it all by getting into more trouble? Drop your thoughts below, because this moment sets the tone for everything that follows.
Okay, that doesn't bother you at all? I can see you don't seem real upset about it. It would be for me.
The $250,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is.
Looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault there, and there was a bond set of, looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right? So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting. And the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris.
This is where things escalate. The judge reminds everyone that Harris was already facing aggravated assault charges for a shooting, yet just 5 weeks later, he's tied to an aggravated robbery. That kind of timeline matters in court. It shows a pattern, not a one-off mistake. Prosecutors will argue that he's a repeat danger, while the defense will try to frame it as circumstantial. But let's be real, 2 violent crimes 1 month apart, both involving guns? That's not coincidence, that's conduct. And the fact that he was still under bond conditions makes it even worse.
It's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled, and so a $250,000 bond was set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th of 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont, with the lights on and the engine running. And observed someone named Arthur Gouldsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant, Harris and Brandon Johnson.
This moment is almost unbelievable. Harris had a GPS ankle monitor, the very tool designed to keep him accountable, and it placed him at the robbery scene. Think about that. It's like leaving your fingerprints on the crime scene, but in real time. Judges hate this because it shows blatant disregard for court orders. The whole point of bond supervision is to keep a defendant out of trouble. Instead, it literally tracks him committing new crimes. Question for you guys. If ankle monitors can't stop someone from offending, what should the courts do differently?
Who were armed with handguns lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got him. You have 3 people at gunpoint and then steal everything, tell them to run and then shoot us. Yeah, Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? When you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And they put him right at the location at the time of the robbery. And so, if that's not enough.
Now this takes arrogance to a whole new level. Prosecutors say Harris posted a video of himself wearing the stolen jewelry from the robbery on Instagram. Let that sink in. Not only did he allegedly participate in a violent crime, but he bragged about it online. That's practically handing prosecutors Exhibit A on a silver platter. Social media has become the downfall of so many defendants because it shows mindset, not just actions. And in this case, it screams recklessness. Imagine being the victim, scrolling online, and seeing your own stolen watch around the neck of the man accused of robbing you.
An Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry that was stolen from the robbery. Okay, there is a motion to increase the bond. Anybody else want to be heard? I've read it, the four corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the ruling. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything state wants to?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into her?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court.
The defense makes a fair attempt here, arguing that since Harris hasn't posted the $500,000 bond, doubling it again would be excessive. But the prosecutor pushes back hard, pointing to the seriousness of the crimes and the rapid reoffending. This is the clash that defines bond hearings. The defense argues fairness, the prosecution argues safety. And the judge? He has to balance constitutional rights with public protection. Viewers, here's a tough one. Should someone accused of repeated violent crimes still have a chance at bond? Or is no bond the only safe option?
Finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and to testify.
So just a few weeks later. I'm sorry, this was on or about July 19th is the indictment date. When he was arrested on or about July 24th for that first robbery that he was indicted for, then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the court the first court's conditions of bond were pretty serious. And in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount and ankle monitoring him did not deter him from committing a more violent crime. So he is in custody and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need. And for the protection of the people and to see that the Constitution works so that we can live in peace, the defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost unfortunately to his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem seem too upset, but there are victims in two different situations, but there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay, all right. That is all.
And there it is. The gavel comes down hard. The judge revokes Harris's original $250,000 bond, declares him a danger to society, and orders no bond moving forward. The reasoning? Simple but powerful. If a defendant commits a violent crime while out on bond, the court has no reason to believe stricter conditions will stop him. And let's not forget, his own mother is now a victim too, losing tens of thousands because of her son's actions. This case is a textbook example of why bond isn't just about money, it's about trust, accountability, and community safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got plenty more coming your way, and trust me, you won't want to miss what's next.